Hello, my name is James Morgan and I'm speaking to you from Radcliffe Chambers in Lincoln's Inn. Not far from here is the West End, which after the last 18 months of pandemic-related restrictions is coming back to life. One of the largest theatres in the West End is the Palace Theatre, which is located less than a mile away on Shaftesbury Avenue. I would imagine its current managing director is delighted finally to be able to open the theatre without restrictions, so that excited children can once again line up to see Harry Potter and the Cursed Child. The Palace Theatre and its then managing director are at the centre of one of my favourite cases, Said and But, a decision of Mr Justice McCardie, sitting in the King's Bench Division in June 1920. Although I did not know this when I decided to talk to you about the case, by way of remarkable coincidence, the events giving rise to it occurred in mid-1919, at a time when the Spanish flu was still raging around the world, although Great Britain had by then seen the worst of it. Anyway, enough about pandemics for the moment. Said and But has all the ingredients of a classic case. Interesting characters, the opening night of a new play in the West End, controversial obiter dicta, and most importantly, a simple case name, for which the hard-pressed barrister is thankfully easy to remember. Mr Said was, according to the case report, a Russian gentleman of independent means. This suggests he was rather wealthy, although I suspect that his wealth pales into insignificance compared to modern Russian emigres living in London. Mr Butt was the chairman and managing director of the Palace Theatre. In July 1919, a light opera was produced at the theatre under an agreement with Mr Said. During the run of the opera, differences arose between him and Mr Butt with regard to the sale of tickets and, quote, serious charges were made by Mr Said against Mr Butt and other theatre staff. The precise nature of those charges is not explained in the report, but it does say that, although Mr Said believed them to be true, they were, quote, without foundation. I suspect we will all recall clients who were honest, righteous, and completely wrong. As a result of these matters, the opera was drawn, and December the 23rd was fixed as the date of the first performance of a new play at the theatre, not involving Mr Said. However, Mr Said wanted to attend, for what purpose is not clear, but his applications for tickets were refused on the basis of the bad feeling his charges had created. Mr Said therefore engaged in what he thought was a cunning ruse to obtain a ticket through a friend. That friend, Mr Pollock, purchased a ticket in his own name without disclosing it was for Mr Said. However, when Mr Said attended the first night, he was spotted by Mr Butt and his entry was duly barred. Mr Said was offered his money back, but he refused, and as you do, instead brought a claim for damages against Mr Butt on the grounds that he procured a breach of contract by the theatre, that breach being not allowing him to actually witness the new performance. The claim, which was plainly not about the money, failed. The ratio of the decision was that Mr Said was disabled from enforcing the contract as undisclosed principal. He knew that the theatre would not admit him personally, that it was not prepared to contract with him, and Mr Said could not get round that by using Mr Pollock's ticket. But the interesting part of the case is the judge's obiter decision that, as managing director, Mr Butt could not have procured a breach of contract between his employer and the third person, providing that he was acting bona fide within the scope of his authority. The judge's main reason for this conclusion was that a servant is the alter ego of his master, and his acts are in law the acts of his employer. Accordingly, just as the company could not procure a breach of its own contract, neither could its employee or director. On the face of it, this has the attraction of providing a simple rule that is easy to apply and provides a neat answer to many cases, whilst at the same time leaving scope for argument as to the exception if the employee or director is not acting bona fide within the scope of his authority. I have a particular fondness for the simple rule because, in a case of mine in 2020, U of N and ADSEX, a deputy judge applied it as part of her reasoning when dismissing a rather complex claim against my client for procuring a breach of contract. However, over the years, a number of judges have questioned the reasoning of Mr Justice McCardie, not least on the basis that the concept of an employee or a director being personally liable for tortious acts is well recognised in a number of other contexts. In one case of the Court of Appeal, Lord Justice Dillon said that he had grave reservations over Mr Justice McCardie's reasoning, but as his reasoning and conclusions had stood for so long and been widely accepted, it was not for the Court of Appeal to interfere with it. So this obiter decision of doubtful reasoning continues to hold good some 100 years on, and will probably remain so unless and until a suitable case finds its way to the Supreme Court. Let us hope that, when it eventually does, the theatres are open and no one is talking about a global pandemic. Thank you.